go right ahead.
Okay, sounds good. All right. Hey, good morning. Wow, we've got a great turnout. We're already up over almost 80 people on board. We've got 100 slots. We're definitely going to fill up. So congratulations to all of you that have gotten on early. And thanks for coming. This is going to be a really important session. And there's been a lot of talk about today's subject over the last year and certainly leading up into the election. But the real key part of our discussion is going to be about Prop 19 and the impact that it's having. There's a lot of good that Prop 19 has done, and then there's some not so good. And there's always a give and take with any piece of legislation that comes forward, and this is no different. But in order to really grasp Prop 19, we really need to go back and kind of take into consideration what Prop 13's original intentions were and how that has morphed and been impacted over the years. We'll move forward into Prop 60 and Prop 90 and how that influenced Prop 13 and the impact it had. And now Prop 19 has come on and impacted those even further. And again, the bottom line in this morning's message is Prop 19 is going to open up a lot of opportunities for real estate. For individuals who hold real estate, it has some consequences. And again, there's some good and some bad. And as long as you understand the impact of these influences and what they mean to your property and how you transfer property, I think people will be able to adapt. And over time, we're going to find workarounds and ways to work with the changes that Prop 19 has brought forward. In addition, Prop 19 has some gaps, and our California legislature is going to have to address those in the session this year. And we expect to have some legislation come forward that may make some further modifications to what Prop 19's intentions were. So we're going to get into all of that. But before we get started, I'd like to take a moment and just thank Dave and Michelle Markham for really enabling this session this morning. Ben Griffin is counsel for Landwood Title, and they've graciously allowed Ben to come forward this morning and share with us. We have a long-standing, wonderful relationship with Ben Griffin. He is the managing principal of Griffin PC, a law firm in Irvine, a long-standing attorney with our previous company, and he's also counsel for our current company. So he works with Berkshire Hathaway Home Services California Properties here, alongside Darren Welsh, who is our corporate counsel in Nevada. Ben is a phenomenal attorney. He's just incredibly versed in real estate and escrow and title, truly the whole package. And I've had the privilege of working alongside with Ben on a couple of situations over the years, and have just been absolutely impressed with Ben's knowledge and grasp. So without any further ado, please welcome Ben Griffin.
Good morning, everyone. Can everyone hear me? Can they hear me?
Yes.
We can.
All right. So I have a virtual background, and I'm very glad to be here. I'm very glad to be seeing all of you once again, although I can't see most of you, but that's okay. I know many, or if not most of you, and I'm very happy that we were able to arrange this. And it's truly been a joy of a lifetime to represent, many of you, if not most of you, and to do many of these in person. I've been doing them for years, and really got to know all of you. So I'm very happy and pleased that, I can come back and do something like this and at least provide some sort of benefit to all of you in a really strange time, we live in. We think about it, and Joe's correct. I mean, a year ago, I was working with him on a prior matter. We were in trial, and we wouldn't even think that, a year from now, we're all on a Zoom. They don't really have trials now. I mean, they do them by video conferencing. They do, everyone's doing these meetings, and we're just waiting for it to be over. We're waiting for, the different issues to work themselves out. And it's been hard for literally everybody. It's been hard staying safe, keeping safe. going in and out of sickness, losing people, as I know many of us have, whether you know them by friends or family members. And so we really want to, that's really the number one message, actually, is to undercut everything Joe just said, which is, family is what matters, friends is what matters. The ability to maintain those connections is super important, and I encourage everybody to do that. Now, I do know that with this virtual background, sometimes my head looks funny, or the paperwork that I'm reviewing might look funny. So I apologize for that in advance. But one thing that, first of all, Proposition 19, it's a constitutional amendment, meaning it's something that had to be passed by the voters. So for it to get corrected or fixed, there's a little bit of regulations, and this legislature can work with that a little bit to fine tune it. But the major parts of it would, for them to be get corrected or replaced or fixed, would have to go back to a vote of the California people. So, and by way of kind of, expanding our horizon, because there's a lot in it that is probably pretty good for real estate agents to sell real estate, because it's a lot of people are going to start selling when they realize that they're going to be paying massively increased in taxes. But as people that maybe own property and have families and have parents, that it could have a different impact, a devastating impact. You think, well, as long as this property will stay in my family and I'll be able to keep it, even if you don't want to live in that neighborhood, but you feel like, I have an attachment to this home and you want to rent it out, it's just not going to, it's going to have some problems. But the bigger picture, the bigger ability here is AB 5 is a good example of that. So you had the Dynamex decision. This, again, doesn't have anything to do with Prop 19. It's just more of what the law is and how California works. Dynamex came out, Supreme Court said no one can be an independent contractor. You have to be an employee unless you meet these like really, spine, issues. Well, right away in California, that was creating massive chaos. Right away, even though the Supreme Court made that ruling, the legislature went back to the drawing board and said, you know what, we really can't do this. We gotta do different things. And so first they, 2017, 2018, first it was one set of laws, and then 2018, another set of laws. And then they had, I think, AB 5 was passed, and then the legislature passed another law. So you see within like 2 years, a massive court decision, which was the law, the Dynamex case, has now been very almost regulated or edited out of existence, or at least more to the status quo. It was extreme, and then over time it became like, well, this isn't really going to work as the Supreme Court thought it would, and so the legislature stepped up. Now Prop 19 is a little different because it is a constitutional amendment, so it's not like the legislature can just go in and pass a law and fix it. But what I am speaking to you about is once the various political actors, whether it's the legislature, whether it's the Supreme Court, whether it's another initiative, once everyone sees how this is starting to play out, and believe me, it is playing out to nobody's business. A lot of people are already, scratching their heads going, wait a minute, we thought, all the marketing was, this is wildfire, hey, this is really a good thing. And again, it is. Your house burns down and you're in a wildfire zone, you should be able to take that. You shouldn't lose your reassessment protection because of that. But as it passed, and all of a sudden, hey, it's going to take effect on, February 16th. Whoa, wait a minute. We can't do this. So now there's every attorney's online, meetings and continuing legal education, and basically it's just this humongous issue that trust and estate lawyers and maybe family law lawyers, certainly some real property lawyers, are now looking at this going, well, this is a big deal. You know, we almost don't have the ability to deal with this because so many people are like, what's going to happen? What's going to happen? What's going to happen? So that's sort of the setup for this. And that is, do I think it's going to be identical to what it is now? No. However, because it is a proposition, a constitutional amendment, that means on February 16th, this will change. The law will expire. So I want to bring forward, I put some notes together. Currently, California property tax is assessed based on the real property's purchase price and the cost of any improvements to the property. There's no change there. So your average residence that you buy, either for yourself or with a spouse or with a parent or something like that, where you want to live. And if you buy a house and you live in it, or you're going to be not reassessed to market value. It's the date of transfer. So you buy a house for 500,000, or you bought a house for 500,000 in 2005. We're now 2021. That nothing's changing with that. Your tax bill is not allowed to go up more than 2%. That's because the Prop 13 protections are still there, and that's not going to change. The issue then would be change of ownership. Okay, well, change of ownership means if you sell the property, whoever buys it, now they're going to be paying the assessed value of the property at the date of that change in ownership. And then they have that tax basis, is what it's called. And that still also is not going to change. So if you sell it, whatever, that's fine. It's not really going to change for things. California, however, they put in exemptions to the change in ownership, and that was to help people. So Prop 13 came about, and it was a reassessment exclusion for if you property request the exclusion, like a transfer from parent to child, or vice versa, or some grandparent to grandchild transfers. It's important to note that the date of death is the date for the date of the change in ownership. But any other transfer, like a sale or gift, is the date of the executed document, in some cases, the recording of the deed. That's just a little wordy and more specific. But and I don't mind using myself as an example. My grandmother passed away in 2015. She had owned that house since the 50s. Prop 13 came in 1978. So her valuation of when she passed away was, it was very low because it was in 1978. That's when it stopped. And then 2% or thereabouts for till 2015. So it was very low. Now, if my father and my uncle wanted to buy, or at least to inherit that property, what those exclusions mean is they said, well, it's not fair. It's a parent to child. It's my grandma to my parent, my dad and my uncle. So if they want to inherit that property, they should be able to inherit it without reassessing it, without losing that favorable tax basis. You know what? It came from your parents. You can sort of step into the shoes of that, and that's great. There's a wrinkle now would be, and both my dad and my uncle would, they just ended up selling it, so it reassessed fully as of that 2015, or actually the date of death. The issue though now with Prop 19, and I'll try to use this example now and carry it forward, which is if that was my grandmother's principal place of residence, which it was, and my dad wanted to make that his principal place of residence, that's now the only way that parent-to-child exclusion could happen. And we don't know whether this is one of those things, we don't know whether thanks, Joe. We don't know whether like my uncle would have to also be living there to get that full exclusion. This is one of those unknowns. We don't know what the Board of Equalization is going to say. They're going to say that's not really fair. The intent is it was my grandmother's principal place of residence. Now my dad wants to live there, and he wants to live in that homestead, the family, homestead. Why should my uncle also have to be living there too? They have their own houses and their own families. Kind of doesn't make sense. So they're hopeful that perhaps that will, but they're hopeful that it would prevent the reassessment for the entire property. It may not. It may be, you know what? Hey, the law is the law. Your uncle would have to live there to get it. Otherwise, you're going to reassess half of it. And then, and so now instead of getting that really favorable tax basis, because you have my uncle's share there, even if, my dad bought out my uncle or something like that, you're talking about a significant increase in property taxes. You're talking about a significant, if my dad doesn't want to live there and he didn't, and my uncle didn't want to live there and he didn't, they ended up selling the property. And I think that's what's just market, because you're talking about really big increases for the most part in taxes. If it's not a big increase, then it doesn't really matter. If the parent bought it recently, between the last 5 or 10 years, and the property tax went up and down and up and down, if the increase will be there, but it's not going to be huge. But if you're talking about multi-decades of properties, just the market force alone, I mean, you're looking at hundreds of thousands over 20 years in extra property taxes. So it's when I look at anything with taxes, you look at it, okay, the government's trying to get money, and they're also seems like they're kind of telling us what they want to happen. Because if you make it that kind of, that kind of a tax increase for your property taxes, most people are gonna say, the heck with that. I can't deal with that. It's too much. I can't, if I'm used to paying, $5,000 a year in property taxes, now I'm going up to $50,000 a year. That's a huge increase. I mean, $50,000. I mean, you're talking what, $4,000 a month in property taxes. I mean, I'm not a math major, so I apologize for that. But in a lot of these, the increase, the dramatic increase like that is actually, if you were to look at it over 10 years or so. But these are still, there's going to be immediate increase if you don't qualify for reassessment. It'll be every single month you have to pay it, or 2 times a year with your property tax payments. But also over time, you see, there's also the fact that it's reassessed. You're just, every single year you're going to pay that higher rate. That's the big deal. That's where these hundreds of thousands of dollars are just going to be piling up, and so that's unfeasible for many people. So that's kind of where we're looking at. There's a few exclusions, specific circumstances. First, to qualify for the exclusion, the parent must have used the residence as their principal residence at death, and the child or children must use the residence as their own principal residence. And again, this is what I mentioned before. It appears from the language it's proposition that all children must occupy the residence as their principal residence to qualify, but it's unclear how this is going to shake out in the enforcement side of this evaluation. In addition, this is a second issue. The exclusion is capped at $1 million or more than your current taxable rate. And it's a very complicated formula. Again, I'm not a math major, so I'm not going to be good at that. And I'll try to give you an example of that in a few minutes. Again, this is only applying if this was your principal resident, or the decedent's principal residence, or actually, it could be the decedent, or it could be you now. If this was your principal resident, this is going to be the child's principal residence. Therefore, you need to understand that if only one of 3 children reside in the property as the principal residence, the property could be reassessed as to the other 2 shares. The reason for the could here is that we do not know how, for sure, how the assessor will deal with this type of ownership. So this is going to be a little difficult, but there's probably examples on the internet. The formula, which again is complicated. One thing is, if the fair market value of the property at the time of death is under $1 million, there's no need for any formula or calculations. So that's big. You need to make sure there's appraisals to support your figures. The date of death determines whether Prop 19 or pre-Prop 19 rules apply, not the actual transfer of the property to the beneficiary or heirs, even if before February 16th. So I'm going to go through this formula. The principal residence at the time of death has a fair market value, let's say, of 1.8 million. That's the fair market value. The assessed value at the time of death, which was the value on which the parent was paying, was only 500,000. Then this is that formula, the 1 million cap more than your current taxable rate. So you have the excess of 1.8 million fair market value minus the 1 million cap plus the $500,000 assessed value. 1.8 minus 1.5 equals 300,000 excess. So you get that, and we're talking about here principal residence to principal residence of the child. So parent was paying $500,000 in assessed values. It's now worth 1.8 million. Now, instead of it being, it doesn't matter what the limit is, now there's a cap of $1 million over 5. So since they're paying 5, you get $1 million. So you actually get 1.5 million, but there's 300,000 left. That's the overage. So now you add the 500,000 the parent was paying, and you pay the 300,000 overage. So even here, you're talking about a new assessed value of $800,000. So that is, now it's not going to be doubling it from 500 to $1 million, but it is going from 500 to 800,000. So it's going up significantly.
Hey, Ben, I have a question for you.
Sure.
So, or I'm just going to say it because I want to clarify for everybody. These are base tax rates we're talking about. This is not Mello-Roos or anything else, correct?
Yes, that's correct. Yeah, that's the base. That is the base. Yeah. Sorry, I'm getting a glass of water. Yes, that's absolutely correct. The base valuation, of course, there's always those extras. There's Mello-Roos, there's, you name it. There's that little list that you see on your tax bill, and you're like, okay, whatever, and it adds up, right? But no, this is just that plain base rate. Okay. What options are available? And I'm going to finish the outline, and then I suppose we'll just go into questions or kind of get it more into what some of the questions are. Because again, there's always like the realtor side is, hey, you're going to probably sell more property, so it's probably beneficial to your business. For the family, for the families, for the property owners, for the inheritances, this is also cuts close to home for all of us. There's a few options to maximize these pre-Prop 13. The first one, which is not appealing, but people are talking about, is to fully and completely gift your property to your children now prior to February 16th. Now, if you have a loan on the property, you're potentially going to get the lender to call that loan if they see that you've just deeded that property over to your child. They may not. If you're current and you've got a little bit left on the loan, and and they see it happen. There may be so many transfers taking place. They're not going to catch it. They're not going to care because they know that, they're still, but technically, usually they're going to be able to do that. So if a parent or a client of yours fully and completely gifts the property to the children, let's pretend there's no loan on it. Here's the deed, you get it notarized, and we record it. It's an immediate lifetime gift. The low property tax will be preserved, but it will likely expose the children to higher capital gains property. The gift of the property is at your basis, which is easiest to think of as your purchase price. Inherited property transfers at a stepped up basis is the value at the date of death. So if you gift your property now to your children, they will lose out on the stepped up basis for capital gain if you gift the property now. By contrast, if your children inherit the property at your death, they will receive a stepped up basis, which is the value of the property at the time of your death rather than the original purchase price. And for capital gains, the rate is currently 20%. And we do have the principal resident has a current exemption for capital gains up to $250,000 for an individual and $500,000 for a couple. So you're helping the reassessment taxes potentially if you just gifted this to your child, but you're now exposing them to a higher capital gains tax. If you believe that giving the property to children is a good idea, you will not be allowed to rent back the property on your terms. Instead, giving the property away means just that, giving the property away. If any attempts to give the property favorable terms of such as you're living in the property rent-free in writing, it might be a disqualifying event. They may say, you know what, you gave it to them, but you're still living there for free, and you kind of just signed the paperwork and you didn't really do that. They would most likely, at least now, we don't know how long that's going to last, but as of now, it seems like the assessors would look at it and say, you're disqualified. You're just, you're trying to live there for free and not get it reassessed, but that's disqualifying you from this exclusion. And then the other part to consider was if you give up all ownership of the property, you risk losing the roof over your head. The children are now the owners for all purposes. They can sell it, they can encumber the property, they can take out a mortgage on it. Their creditors can attach the property, or their spouses may have potential community property claims. In other words, a creditor or a third party could end up with your home. So you want to make sure you're not hastily giving it away. Sorry for that. I have to keep the throat while I'm talking so much. There's other sort of complicated issues. Lawyers are thinking, is there a way to have some sort of a trust issued to sort of weave a way around it? Enterprising lawyers in the trust and estates field are looking for that. That might work. Many lawyers are doing it. Many lawyers are not. I'm not in that field, so I don't pretend to say, hey, I know exactly what their trusts are. But that's something they're doing is these intentionally defective grantor trusts, IDGTs, which I've been seeing on the legal chatter that I review by email every week. Seems like that people are really trying to invent a good way to make this work, where you can put the house into trust. It's still it's preserving the property reassessment, and yet the children will get that property eventually. So they're trying to do it. I give them a lot of credit for that. I just don't know if it's going to work. Another one you can do, what you can do is, if one of your children desires to maintain the property as their principal residence, you can make that specific bequest in your estate planning of that real property to that child. However, if it's possible this will lead to inequitable distributions if you have more than one child and your assets cannot adequately equalize the distribution. What that means is they're getting such a benefit of that property. If you don't have enough cash to make up for the other for the other children, you could one child could get, you know, a $500,000-$800,000 residence that they don't really have to pay that much property taxes on. But if you don't have $800,000 in cash or other stuff to give to the others, you know, you're not you're you know, you're just, it's going to be difficult to make that happen. Otherwise it'll be unfair. And then all of a sudden, what happens when it's unfair? They start suing each other. Oh, you always love Johnny more than Tim, you know, it's like, oh man. But that's what happens. People get mad, they start suing each other. And you don't want that. You just don't want that. Now, there's other aspects of Prop 19 that I haven't been talking about. There are very positive aspects. Individuals over 55, this is great, actually. If you're over 55, you can transfer your tax basis to a new home in any county in California for up to 3 times over their lifetime. And as long as the property purchased is less than the previous, there is no reassessment. But now you can purchase property, you can exceed your prior basis in another, in other words, if you sell your home for $1 million and you have a $500,000 assessed valuation on it, you can, if you sell it and then you move to another county in California for $1 million, you get to keep that $500,000 assessed value. So it's just anywhere in the state. Before you could do it, I think 1 time in your own county. Now it's up to 3 times anywhere in California. So that's a pretty significant benefit. If you buy something more expensive than what you're selling, so if you sell your property for $1 million and you want to buy $1.5 million, you keep your old basis and then you only reassess the extra, the $500,000 more extra. And then again, this is what was like all I heard about during the precursor to the election was the fire victims and qualifying disabled individuals will be able to benefit from this proposition in certain circumstances. So the big thing is that's really what it is. It's principal residence to principal residence, and you've got $1 million cap. That's it, and that's why everyone's freaking out, because if you have 3 homes and you have 3 kids and you thought, hey, I was just going to send them to all 3, now it's not really going to work that way. You can't. One kid gets the value, the beautiful valuation, and then the other, let's say, pretend all of them have the same value, assessed value, and the same property value. Now one of them is literally going to get a like the gift of a lifetime, right? And then the other 2 are going to be reassessed completely, because you can't do that. Only one was the principal residence of the parent. So 2 of them are basically going to be forced to sell. I don't see any other way of doing it, because if you were to try to make that property tax value, if you're trying to be fair and equitable amongst all 3, you have to give extra cash to the 2 that are going to be paying much higher in property taxes to account for this. So if they do that, you're literally, you run it out 20 years, depending on the numbers, you're literally talking about 100, 150,000. I just saw a scenario this morning where each, you know, there's 3 residents, 3 kids, 1 was a principal residence, because they, you know, don't have to repay their taxes. They're still paying this, you know, really low value in property taxes. The other 2, you run it out 20 years, I think you're talking like $150,000 in property tax extras per home, per the other 2 kids. So that's $300,000 in cash that you have to give the other 2 just to make up for the unfairness of it. So it's it's really uncertain, and it's going to cause people just to sell. We are going to get, you know, future guidance from the Board of Equalization The issues are going to get fleshed out. People are going to be suing. People are going to be trying to fix this. But we don't know what that's going to turn into. We just don't. So that's my sort of outline, my overview, and you know, and I'm happy now to have more of a discussion. I can't promise I'll have all the answers because we just don't know a lot of these things. This is, you know, it's a brand new law, but I am willing to see if there's discussion or if Joe has some comments here.
Yeah, Ben, we've got some questions in the chat here. But before we jump into that, yeah, as Ben just said, we don't have all the answers right now. And even the county assessors sites are all stating that they're waiting for the State Board of Equalization to give them some guidance. And that means we're really waiting for some legislation this year to clarify some of these things. But just to summarize, before we get into Q&A, there's a couple of key impacts here. One, and let's say from the perspective of real estate and from our world, what does this really mean to our market? This Prop 19, a big part of it, the base year value transfer for seniors, people over the age of 55 or people who are disabled, that component was something that the California Association of Realtors has put on the ballot previously, spent literally $40 million to try and pass that legislation, and it didn't get through. Now, this time, this legislation was bundled with some other things. And one of them was, and if you saw any of the advertising during the election, it was presented as though, hey, this is going to help seniors, this is going to help disabled, this is going to help disaster victims of wildfires and other natural disasters, and it's going to punish the rich. And that was really how it was promoted is, oh, we're going to stop the evil East Coast investors and the celebrities from transferring their $7 million Malibu beach house from child to child as a second home, you know, a summer home or a vacation home or a weekend getaway. And so that was one of the things that was represented. What that didn't translate to is it meant it was going to impact anyone who was transferring additional real estate. You know, there's still the carve outs, as Ben mentioned, there's still carve outs for you to transfer your property to your children if it means something to them and they want to live in it. But if it's an investment property and you have a portfolio of 4 or 5 rental properties, you want to pass those on to the kids, that's not protected by this process anymore. So those are really the key components. But one of the real blessings of this that the California Association of Realtors was trying to promote for so long was the idea of seniors being able to transfer their tax base more than once. And let's just go through the scenario. So you purchase a home, you're a young married couple, and you raise your family there, and it's a family home, and it's a larger home. Maybe it's 3,000 square feet, and it's got 5 bedrooms. And then the kids graduate, and they go on to college, and pretty soon you realize you don't need that big of a home anymore. But you know you only get to transfer that tax base once. And so you hold on to that 5-bedroom, 3,000 square foot home longer than you really wanted to because you want to only do it once when you go to your smaller single story forever home. Now seniors, when their kids graduate and move on, they can move down to maybe a 2,000 square foot home or a 2,200 square foot, 3-bedroom, 4-bedroom. And then they can do it one more time to their single story home that is in a 55 plus active living community or something like that. So what that does and what it means to us from our marketing perspective is now people can move out of their homes and still keep their tax base and move. So what it will do is in a community like we're in this Inland Empire where it's been 25, 30 years in development, a lot of these homeowners are hanging on to homes that they really didn't need anymore. And so California Association of Realtors' perspective is that it's going to allow more homes to come on the market for families that really need them and allow the seniors to take that tax base with them multiple times. So that's a real big benefit for what we're looking at. However, I will tell you, be careful. When you are speaking with clients out there, not everyone is a fan of Prop 19, and especially the investors that have 2 or 3 rental properties, and they're reading this and they're asking, hey, did you realtors vote for this? How come your association promoted this? And so we've got to take the good with the bad with it. And again, that's what we're talking about today is there's a lot of good, but there's also some impact to families who want to transfer these things. Now, what we've found over many years is these things work themselves out. And legislators find themselves in the same situation. They want to transfer their properties. So let's wait and see what California does in this legislative session and how much of this is fixed. So again, the good with the bad. Let's get into some of the questions that are on here. So if the title is transferred to a living trust, does it apply the same way? I think everyone has that same question. If the homes are in a living trust, whether it be revocable or irrevocable, does that protect this scenario? And again, the two things we're talking about, Ben, but can you address one if it's principal residence and one if it was just investment property?
So if it's a, the law will generally seek to look through that trust to see what's really happening. So it's not enough to say, well, here's the trust and I've conveyed it to a trust. And, that trust is an estate planning tool where you separate the ownership from the beneficiary. So the trustee is in charge of the trust. And so if you put your property into trust, you're what's known as the settlor. You have now conveyed it from you as an individual to you as the trustee. And who are the beneficiaries? Generally speaking, while I'm alive, I'm the beneficiary. And then when I pass away, then it goes to my children. So if you do that and you have an estate plan with a trust where the estate planning attorney has drawn up the documents, they will then convey that property to the trust. And if that's your personal residence, if it's my trust and I convey it to this trust, and then upon my death, it goes to my child who then wants to be the principal, it wants to live in my house, then yes, that will protect it. But just the trust by itself doesn't provide any way of dealing with this. That's why I briefly referred to that IDGT trust that estate planning lawyers are trying to do, intentionally defective grantor trust. They're trying to invent a way of going around this. Many lawyers are not doing it because they don't think it's going to be successful. But no, that just the fact that you put it in a trust, it's great for estate planning purposes. And I encourage you to do that, or to recommend your clients do that. But the law or the assessors will look at what is actually going on. So if you convey it to your trust and you still own it, it hasn't changed ownership. You're still the beneficiary. You're still the beneficial owner. So if I convey it to my trust, they don't reassess it because I'm still living in it. It's still my house. I just put it into estate planning trust. Upon my death, one of my sons gets it. One of the twins. I don't know what the other twin's going to do. But one of my boys gets it, and he wants to live here. So then he gets that. He's going to get that protection. If he says, no, I don't want to live there, I'm just going to rent it out, then it'll get reassessed. It won't be protected, and it really won't have to do with the trust. But they are trying to come up with ways to deal with this.
Perfect. There's a question there from Rhonda that she'd sent it to you. I'm not sure if you can see the chat, but what I can see of it, I'm not clear on. So see if you can find the question from Rhonda Hill. Meanwhile, a follow-up on the main reason CR promoted this was for sales. We have a really severe housing shortage in California. And it wasn't really self-serving that CAR was promoting this. It was trying to assist the state in addressing the fact that we are 2 million homes short. Actually about 2.5 million homes short in the entire state. And the great majority of that, over 1 million of those homes, 1.5 million, are in Southern California. And we just factually do not have enough homes. Builders have not built as quickly as they used to over the last 10 years, and we need them to pick up the pace. But meanwhile, this housing shortage is artificially and dangerously inflating prices right now. And so the legislature and CAR both wanted to allow seniors to be able to move from their homes when they wanted to. It wasn't to create an opportunity for more sales, but that was the end result. So again, some positive came from it. The trust transfers, we're seeing a lot of questions here about the trust transfers. And again, that used to be a great answer. And then you had the parent-child gifting, which I'll put back on the screen here. But it allowed you to, from a parent to child or a grandparent to grandchild, you had an exclusion. And unfortunately, there's some trigger dates that we need to pay attention to right now. And the first one is February 16th of this year. So just a couple weeks away, this changes. And what changes is the transfer. Let me get back up to the parent-child transfer, I'm sorry. So what changes in the transfer is effective February 16, 2021. Again, you can still transfer it from parent to child or grandparent to grandchild and be exempt as long as the parent or grandparent lived in the home, primary residence, and the child or grandchild, the grantor and the grantee, both will use it as their primary residence. It's just eliminating exclusions for other investment properties. But that happens almost immediately here in February 16th. Because of that, your estate attorneys, your tax planners, your CPAs, everyone are being overwhelmed with questions and meetings to try and address these things before that deadline. The other trigger date, let's just cover that real quick, for the transfer anywhere in the state of California by seniors over the age of 55, that has an effective date of April 1st of 2021. And there's some caveats with that. Again, remember that you can use this exemption and you have to purchase your replacement home within 2 years of the sale of your previous home. And you can actually do it the other way around too. You can sell your previous home, buy your replacement home within 2 years, or you can buy your replacement home and then sell your existing home. So you can do that either way, but there are some caveats. As always, when you're talking about this with your clients, remember, say, I'm not a tax professional or an attorney, you should seek proper counsel. So this is really a guideline to understand their perspective and their positions. We still need to push them back to professionals. Ben, did you were able to find that question?
I did. So I've got a question here, here in this message. Home is in a trust. The individual is a trustee, apparently trustee of that trust that owns the house. And then it's kind of goes on to a different area. It says the will says I can stay in the home. So I'm not certain. Usually if the house is in a trust, then the trust should control, not a will. The will should be sort of secondary. But it says the will says I can stay in the home until the trustee no longer wants it or dies. The individual has 2 siblings that are not trustees. And then it refers to a she, and I'm not sure who that is, transferred the property that allowed her to bring from a different home. So
Ben,
yes,
that's
yes.
my question. So I can clarify.
Okay. Sure, please.
2 separate issues. I was added as trustee, so there's that. My 2 sisters are not. They are beneficiaries as well as myself in the trust. Okay.
Okay.
The will, though, the specificity of the will says, without me being trustee, that I could move in and stay in that as my primary residence for as long as I wanted to, or until I die. So if I want to sell it, at that point, the will takes over and the distribution occurs according to the will. When I said she, my mother lived in San Bernardino, and she transferred that tax rate over to this new property in Murrieta. So that sort of clarifies if that helps.
Okay. So under Prop 19, this is only having to deal with parent to child. So the issue here would be, let's say you kept living there for another 20 years, which you're allowed to do, there will be no impact on the assessed valuation until an event took place. So either if you pass away 20 years from now and your sisters now are going to inherit that home, I don't know for certain. Again, this is a little bit outside of, this is more of an estate planning type of a question. But I believe the law would still look at it as this is still a parent to child. I think your sisters might be okay, but I just don't know. I don't know if they're going to look at that as actually that was really your sister who kept living there as her principal residence, or if that's really mom's principal. And it's really mom to your 2 sisters, and that they get to inherit that.
Yeah, no, they're never going to inherit it. It gets sold. If I don't want it or I die, it gets sold. They don't ever inherit the house.
Okay, so so the Prop 19 reassessment there would be no triggering event for that.
Okay,
So
perfect.
if you sell it or if you die and it gets sold, either way, they're going to, the new buyers have to pay the new price. So this wouldn't have any impact on that.
Perfect. Thank you.
Yeah. Hello?
Joe, I think you're muted.
There we go. I'm sorry, I had to stop the share. So yes, quick shout out to Yvonne Ramirez and Legendary Escrow. They provided us with this worksheet. It's Prop 19. What does this mean for you? That's a great resource for you. It was emailed out to everyone. It's also going to be in their library. Landwood Title is also doing the same thing with the Prop 60, Prop 90 flyers being updated and a Prop 19 flyer. So great resources from our support systems. Just stay tuned. This is going to continue to change over the next few months. But again, 2 trigger dates right now, February 16th for the transfer without the reassessments between parent to child, grandparent to grandchild, and then April 1st for the seniors being able to transfer their properties between any county in the state of California effectively, and to be able to do it multiple times. Want to do a quick pre-promo for what's upcoming here about the middle of the year in May. Watch for a very, very important legal update and brief on the new laws, the new forms that are coming, and a preview of the new purchase agreement. CAR is completely overhauling the purchase agreement, and you'll see that coming out at the end of this year, but we'll see a preview of it in about May. So again, it's here, Prop 19 by the application basis of the 6090 in the county tax assessor. Yeah, so right now there's some great resources at each of the county assessor site, primarily for all of us here in Riverside County. Riverside County's got some great resources, and a lot of this information that I've been sharing this morning came from that website. And within the pages, there are active links where you can click on something, click here to access information on filing the base year transfer, click here to view the parent-child exclusion information and the application. So there's a lot of great resources right on the website. And again, you see that there's the qualifications. This chart's developed by the State Board of Equalization, and it's still pending some revisions. Let's see other questions. No, I don't see anything else. So again, a great big thank you to Ben. You're amazing. We've appreciated you, and we continue to appreciate your wisdom, your knowledge. Big thank you to Landwood Title for helping facilitate this and allowing Ben to come to us this morning, and their generosity in making that happen. Any other final questions?
Thank you, Ben. I appreciate it. It's been really helpful.
You're welcome. My pleasure.
Okay, well, without any final questions, thank you all for taking the time to be here this morning, and stay tuned. More information, more resources will be provided to you through your managers. But again, great times ahead. 2021, let's make it the best ever. 2020, with all of its challenges, was really an amazing year for real estate. Let's continue that momentum into 2021 and beyond. So thank you everybody for being here.
Thank you.